happened in the last 13 days. It has happened today. But as he's on his way, I thought I will take the time to... The other day I told you about the concept of national human rights institutions. I think we should understand what are national human rights institutions in India. We have, as I told the other day, once again I recollect, we are the only country in the world to be having over 170 human rights institutions. No other country in the world has this many institutions. We have them at the national level. We have them at the state level. At the national level, we have the National Human Rights Commission, about which this course will deal later. The National Commission for Women, the National Commission for Children, the National Commission for Minorities, the National Commission for Scheduled Castes, National Commission for Scheduled Tribes, the Central Information Commission, and the National Commission for Safai Karmacharis, which is for the abolition of manual scavenging in this country. Now, at the state level, there are some states which have many commissions. There are some states which don't have commissions, all the commissions. Most of the states have a Human Rights Commission, a Women's Commission, the State Commission for Protection of Child Rights, Minority Commission sometimes, and the State Information Commission. This is almost sure. In addition, they may have an SC Commission or an ST Commission or a Special Commission for Abolition of Manual Scavenging, which is at the state level. What is to be understood? That there are connections between the national and the state based on the law that they are created under. And therefore, the National Commission for Human Rights and the State Human Rights Commission have a connectivity because they are both created under the Protection of Human Rights Act. The National Commission for the Protection of Child Rights and the State Commission for the Protection of Child Rights are similarly connected by a common law, the Commission on Protection of Child Rights. The Central Information Commission and the State Information Commission are another list of institutions covered under the Right to Information Act. These are the three national and state institutions which are linked because they have a common law. But the National Commission for Women and all the state commissions for women are totally independent. So that is a separate law, and every state has its independent law. The same with the Minority Commission. National is separate. The state commissions for minorities are separate. The same for the National Commission for Scheduled Castes and Scheduled Tribes. These both are at the national level, and at the state level, if there are, they are under separate creations. The National Commission for Safai Karmacharis is the same. We have separately at the national level and separately at the state level. One factor that has to be understood by all of us is the fact that all these commissions, though sometimes they may be under the same law, the National Human Rights Commission has no control over the state human rights commissions. The National Commission for Protection of Child Rights has no control over the State Commission for Protection of Child Rights. It is not that they are senior and these are hierarchically subordinate to them. And the same with the CIC. So this is the structure of institutions in India. The problem with these institutions is that most often we don't have people who have not been trained before they were appointed, and therefore they are unaware of how they are to function, and they have to enter the commission and learn the process of how they will function. In this scheme, you also have more or less the same type of functions that all of them do. And if you want to put their functions together commonly, they all are engaged in creating an awareness about the rights that their commission covers. So awareness of rights is something that they are to be engaged in. All of them are also meant to be advising the government. So awareness, advising the government. And the third function is to be handling complaints. So awareness, advising, handling complaints are the three large functions that all these commissions together do. Special factor in these commissions, and I'm making use of this time so that when I have my session tomorrow, it'll be easier for me. These commissions collectively, all of them, have what is called suo motu powers. Please write down in the chat. If somebody can put it down there, that will be nice. Suo motu powers. And the suo motu powers are that the National Human Rights Commission reads in the newspaper various incidents that have taken place, and without a complaint coming from the affected person or a person representing the affected person, can on their own, through newspaper reports, through radio news, or through television, or any other source, on their own accord, take up these complaints and proceed further. So suo motu powers is a very powerful weapon that these commissions have. Naturally, there are 200 questions in your mind. Why is it that there are lots of newspaper reports which are shocking to you and me, but not shocking to them? That will decide whether those commissions are independent or not independent. And largely because they are not independent, they are unable to do what they are supposed to do. So we have seen now so far the fact that there are institutions established. These institutions are established at the national and state level. We have seen in general what they are supposed to do in terms of their functions. Their specific functions will change. And third, we have seen that they have suo motu powers. I will go into one more thing which is common. And please note, some of these commissions invite students for internship. They all have websites. So please go to their websites. Some have websites which are inactive for years together. Please don't curse me for that. But there are commissions which have regular internships. The National Human Rights Commission has what it calls a summer internship and a winter internship. And they also offer a stipend. And for those students who are interested and who have a lot of courage, that even if it is a tough time, you will manage, then go. You understand what I mean? Your heartbeat inside the commission will be different from your heartbeat outside. Mr. Parasha's heartbeat outside is different to what it was 24 years when he was inside, or at least part of the 24 years when he was inside. So internships is something that you should look forward, because we have a large number of students and academia here. And please pass it on to your students. Please put it on your websites. Open universities, advertise about them. Don't advertise only your course. This is something of a good experience. The second activity that you can all be engaged in, and some of the colleges with which I've been associated for decades, I've been speaking for decades, please write to the National Human Rights Commission asking for assistance, asking for financial assistance to run programs for awareness on human rights in your respective universities and colleges. Very important. They have money. You ask, then you will get it. You decide you don't want to ask, then you'll never get it. They have money in the National Human Rights Commission for seminars and conferences. I know some of you access it, but I think many more should access. I know there are law students here, law students even from Madurai. Please tell your principal to apply, and he or she will be allocated if you do it on time. And it is quite a nice sum to create awareness among students and staff on human rights. I do a number of these programs when invited. And they say, sir, how many people? 50 people. I say, please, you do your course for 50 people, but for the inaugural, have about 300 students so that we can create awareness to 300 students and reach out to a large number. So training programs are available. Research funds are available. NHRC has research funds. I'm going to tell those who are handling the NHRC not to get into this. There is research funds available, and we will send you links. Raja will just take note of the links, research funds links, training program links. And the third, the National Commission for Women has money for research studies as well. So these are all funds that are available with these commissions, and it's going to be one of your activities to be able to look for these connections from inside and then go and take it back to your respective institutions or use it personally or share it with friends. These are all benefits that you can have in addition to complaints handling that they should be doing at this time. But what is sad today is our collective conscience has been shocked. And I'm sure you will raise it with Mr. Sanjay Parikh, who's to come. Shocked by what has happened about the migrant labor situation in the country. As I told you when Usha was talking that day, and I'm sure it has happened to most of you, I had tears in my eyes of shame, not anger, shame. Because a true human being has also to be ashamed at times. That cleanses our system. People might think because I have a big mustache, I speak loud, I'm very strong. I'm an ordinary human being with all the qualities of a human being. And tears in our eyes are also good qualities. We should learn to cry. We should learn to be seen for us to be able
Henry,
to pass to people. Yes?
Sanjay Parikh has come online.
Okay. Friends, so this much I will not repeat when I do my session tomorrow. See, this is what you call in Tamil Nilaya Vidwan. So that's the Nilaya Vidwan I will not spend 1 minute wasting. I will straight away take you to Mr. Sanjay Parikh. I need to only see where he is.
His screen name is admin.
Admin, yeah. Sir, are you coming on your video, sir?
Yeah, I am seeing you. I was listening to your beautiful oratory. Good
Good morning, sir. Good morning, sir.
morning, good morning.
Friends, I'm sorry. This is a late start today, but we have started our class, part of our class for tomorrow. We have in our midst, I won't waste a minute now, we have in our midst a very special person. Friends, that is the problem. We should bring before you people like Tushar Mehta and others, who call people like Sanjay Parikh and myself self-employed public interest litigants. But we bring to you good people. But the reason for bringing to you very special people, I don't say good people, special people, is for you to have hope that all this is possible today. And you have today a very senior person in age and a designated senior counsel of the Supreme Court of India. Don't ask me for doubts on what I said now. Anything else? Yes, all those doubts should go to him. Mr. Sanjay Parikh is from Delhi. Has been for all his life associated from the time of its establishment with the People's Union for Civil Liberties, the premier civil liberties organization, as I've always repeated in this course, founded by late Mr. Jayaprakash Narayanan and headed by late Justice V.M. Tarkunde, and later by many others, including Mr. K.G. Kannabran, whose daughter, Kalpana Kannabran, you were able to meet recently. He is today the executive committee member of the Indian Society of International Law, a vice president of the PUCL. He appears in courts as well as the National Human Rights Commission on very significant matters. One of his very special contributions of the many has been hunger deaths, assisting the NHRC in its hunger deaths in the KBK districts of Orissa. Now our friends from Orissa will get very excited because Orissa was mentioned. Mr. Sanjay Parikh is known for his ethics. Very special things that we need to highlight about people. He's a very ethical person. And he still continues to uphold ethics in the way that he understands it as well in his practice within and outside court. And I value him especially for that. He is able to withstand all the tensions that court sensitivities and insensitivities of court place on him on a daily basis. On a daily basis. And sometimes we ask him, how do you do it? He's a writer. He writes poems. I was looking whether there was any art of his in his room. I only see a scene photograph. He is an artist. Now it's important for us in our activism to bring in talents like this to keep the humanism within us going. I will stop here and just say one thing. He is our lawyer. Our lawyer in a tough matter. And the tough matter is, all of you know that our bank accounts are closed now for 2,000 days. I'm saying it because now with Corona, Mr. Sanjay Parikh must have lost track of the number of days. Not the case. 2,000 days. Imagine your bank account being closed for 2,000 days. We survive because of the energy he possesses and he passes on to people like us and say, hopefully go ahead. I remember his words in the year 2014 when we first won in the court. He said, Henry, leave the court, go and carry on your work. That is more important. So this is a friend that we are sharing with you. He is Medha Patkar's lawyer for 30, sir, 30, am I correct, or 30 plus?
It will be more than 30 years, but then 30 is all right.
More than 30 years. And I have seen Medha Patkar sitting in his chambers, sometimes with tears in her eyes, communicating to her lawyer about how he should be able to somehow get an order. That is the relationship he has with his public-spirited clients. I will stop here. We have Mr. Sanjay Parikh to speak to us about the courts, the lower courts, the higher courts, the higher judiciary in this country, not the institutions, because that is going to be handled, and how they contribute to human rights through various jurisprudence that they follow. Over to you, sir. You will have about 40 minutes now. I hope we will, and then for 20 minutes of, 15 minutes of question and answer. Over to you, sir. Thank you, sir.
Thank you.
Sorry for this confusion about the timings. I'm very sorry.
No, it's not your fault, my fault. The corona effect.
You can
Thanks.
start.
I can start.
Yes, sir. You can start, sir.
Yeah. Friends, I'm very grateful to Henry for giving me this opportunity to speak to all of you. I'm also feeling little embarrassed in the sense that Henry has spoken so much in introduction about me. I do not know how much of that I deserve. But I'll tell you only one thing. There is something, which is inside. You have to cultivate things inside you. And the reflection of whatever you do should be the reflection of what is inside you. And that is something which is permanent in nature. That doesn't actually dissipate in any sense with the passage of time, because the source of energy is something which is different. It is coming from your consciousness. And that's what I feel. Poetry and paintings, etc., are a part of that very expression, but I think it should be linked. It should not be something outside source, which is for a temporary period, and it disappears with the passage of time. That's not the true way, and that's probably one way in which we understand the Karma Yoga. But something which is higher than that, and I think if we inculcate that in life, it will be a wonderful thing, because it's not only for your own self that you work, because getting food, getting a shelter, the basic requirements, probably you can fulfill in any way. But beyond that, is something which is required to be done for others. And that's actually the basis of what we call dharma in the real sense, not the way in which it is being understood, of life as well as existence. My topic is not very, if I have to speak about certain things, what is happening today in a situation and how the government has messed up the entire thing, I think I'll be like Henry, little emotive in the sense, and will be able to say so many things very strongly. But I have to today explain to you how our court systems work. And I am therefore going into only that area, not going into so many other areas on which probably I would like to speak to you and share my views on some other occasion. If you look at the structure, the hierarchy, we have on the top the Supreme Court of India, then the high courts which are located in different states, and under the supervision of the high courts, we have the district courts. Now the district judiciary, or district courts as we call it, basically are involved in two kinds of discharge, two kinds of functions, and we divide it as a civil and criminal courts, or court system. Now, as far as the civil law is concerned, or civil courts are concerned, we have the district judge, who is head of the district judiciary, and under him we have the civil judges senior division and civil judges junior division. That's the hierarchy. Now the question is, what kind of litigation can be brought before them? It can be a property dispute. It can be with the disputes concerning the Transfer of Property Act. it can be dispute relating to marriage, it can be dispute relating to guardianship, and plenty of those things which are covered under the category of, as we call it, the civil disputes. So depending upon the cause of action, where the cause of action is arisen, and the pecuniary jurisdiction of the relief which you are claiming, that you will have to approach either the junior division, the civil judge junior division, or the senior division, civil judge senior division. In certain cases, the jurisdiction will lie with the district judge. These suits, they consist of that you have pleaded, the pleadings, will be that the plaint which you have filed before the court, in which you state what's your grievance as such in a plain language, and seek the relief, prayer portion. Then there is a written statement. After written statement is filed, then there are admission, denial of documents. Then there are issues which are framed. Then the evidence is laid, culminating into judgment. That's actually the entire structure as far as the civil courts are concerned. The civil courts, for example, cannot issue a writ. The civil court doesn't have jurisdiction to strike down a law. That's not permissible. But under Section 9 of the Civil Procedure Code, the jurisdiction of a civil court is very vast, unless it is curtailed by some special enactment, like we have the Industrial Disputes Act, where a workman has to approach the concerned forum, the tribunals or the labor courts, whatever the law provides. Otherwise, in most of the cases, like even revenue matters are there, where the civil court will not have jurisdiction, except to the extent it is provided relating to title, etc. So the jurisdiction of civil court is very wide. The question comes in that what kind of, if you want to do something relating to the public as such, the public causes, is there anything which is available within the civil court jurisdiction that you can approach, not for your own grievance, but for the others? So certain provisions are there. One is that you can file a suit for a number of people for the collectivity, which is known as the representative suit. You may take a particular cause, make them parties, and then approach the court for getting relief. So many times I have suggested that not necessary that in every case you approach the High Court under Article 226 of the Constitution, or for that matter, in the Supreme Court under Article 32, because certain reliefs locally can be granted by the civil courts. For example, recently, there is something happened in Pondicherry that some people were trying to, and the builder lobby was trying to encroach upon the road, the public road, which has an access to the village. Now, they were thinking that they should go to the High Court, file a Article 226 petition. I said it's an easementary right, and those who are enjoying that right for say several decades can certainly go and file a suit for injunction stopping them from this kind of a problem that no construction can be made. Similarly, as I said, a suit, the collectively, which is representative suit, where all the villagers and other affected people could have filed. So it is easy to get an injunction stopping that person, then filing a writ petition under Article 226 of the Constitution before the High Court. The other important provision you'll find in Civil Procedure Code is Section 91. Now, Section 91 says, it talks about the public nuisance and other wrongful acts which are affecting the public at large. So a suit for declaration or a suit for injunction can be filed. It can be done by the Advocate General, and if Advocate General is not filing it, then with leave of the court, two or more persons, even if no specific damage has been caused to them, can approach the court against the public nuisance or wrongful act. Now, this is another provision by which not the individual cause, but generally cause of the public can be taken up by the civil court. I think it's all right. We have another provision which is section 92. If there is a trust which is functioning and the trust is not doing the charitable work or acting according to the aims and objects of the trust, the Advocate General can approach the court, or two or more persons having interest in the trust, they may be beneficiaries as well, with leave of the court, can approach the court. This is another provision which is not relatable to your personal list as such, that your property is affected, your personal rights are affected, but generally which is affecting rights of the people. You can also file a suit against the government after giving notice under section 80. That's also important, because if you find that any act of the government, usually what happens is that if there is a government act which is affecting the people, we rush to the High Court under Article 226 of the Constitution. But in so many cases where you are properly advised by a lawyer, you can give a notice, and after giving a notice, you can file a suit for injunction. You can also file a suit for declaration. Now, I'll only refer to one of the cases which Justice Krishna here dealt with. It's a very famous case, Jolly George Verghese versus the Bank of Cochin. The affected person was not able to repay the loan, and therefore there was a decree which was passed against him. Now, the decree, he could not pay the money, and therefore the court directed that he should be imprisoned under the provisions of CPC. It is at that juncture Justice Krishna here brought in the public element, and I am referring to this case only for that particular purpose, referring to Article 11 of the Civil and Political Rights and Article 21 of the Constitution. The court said, speaking through Justice Krishna here, that a poor person, if he is not able to repay the loan, in that eventuality, it will be totally unjust to imprison him. And therefore, directed in those cases, the court cannot pass a decree for imprisonment that till he pays the loan. The exceptions he carved out was only if it is deliberate, it is wanton, it is for some other reason somebody doesn't want to pay, that the imprisonment will be there. So this is how Justice Krishna here brought in the element of the constitutional provision like Article 21, which talks about the protection of liberty, personal liberty, and life as such, including livelihood. So these are some of the basic structure as far as the civil code is concerned. Now, any order or judgment which is passed by a lower court, like the civil judge junior division passes an order, then the appeal will lie before the senior division, and then after appeal, the second appeal will lie before the district judge. If the order is passed by the civil judge senior division, then appeal will lie before the High Court, and then ultimately the special petition which lies before the Supreme Court. That's the hierarchy in which the civil courts function. If there is any kind of a question, I'll take that question at the end. The criminal courts, the district judiciary is similarly divided into the same hierarchy, where on the top of it you will find the sessions judge, and in certain cases where another judicial officer has been authorized to work as additional sessions judge. So the sessions judge or additional session judge they exercise the same jurisdiction. In the metropolitan cities, you have the metropolitan magistrate and the chief metropolitan magistrate. The other places, you have the municipal magistrate below the sessions judge, one municipal magistrate class 1, and below him the municipal magistrate class 2, and one of them, who is municipal magistrate class 1, is asked to function as the chief judicial magistrate and is given the administrative power of allocating the cases when it comes up for hearing before a particular court, that which court should hear which kind of a case. His administrative power is given to chief judicial magistrate, like chief metropolitan magistrate in certain cases to the sessions judge or to the additional sessions judge. Now we have certain important things in as far as the criminal law is concerned. There is something which is known as the cognizable offense and non-cognizable offenses. Now the cognizable offenses are those where a police officer can arrest without warrant. Non-cognizable offenses are those where the police officer cannot arrest unless there is a warrant available issued by the court. There are cases which have been summons cases, warrant cases, which have been defined in the Criminal Procedure Code. The warrant cases where the punishment is life, death, or above 7 years. That is more than 2 years. So less than 2 years or less than 2 years are the summons cases, and above that are the warrant cases. Then there are offenses which have been made bailable. There are certain offenses which are non-bailable. Now the question is, when a crime happens, then a person can go and report to the police authority, which we call as FIR. Now the Supreme Court has said in one of the judgments by Constitution Bench that in that eventuality, when there is a information about commission of a cognizable case, then it is mandatory for the police to register the FIR and start investigation. We find that in spite of the judgment given by the Supreme Court Constitution Bench, it is not happening. And that's something which is a sorry state, because not only this case, so many other cases where directions are given by the Supreme Court, they are not followed, including the cases, directions which have been given by the Supreme Court with regard to, in D.K. Basu, with regard to the guidelines regarding arrest, etc., what is required to be done in case the person is arrested by the police. Now, if the police does not register a case, FIR, then you have an option to file a complaint. Now, the complaint has to be filed before the judicial magistrate. The judicial magistrate records the statement and thereafter he can issue summon himself, take cognizance and proceed with the matter, or under 156(3) of the Criminal Procedure Code, it can be referred to the police for investigation. So commission of offense, two ways. Number one, through the FIR process that the police will investigate. If the police is not registering your complaint, the information as the first information, then you file a complaint. Then your complaint, the magistrate will either direct the police to do the investigation, or will record your statement and proceed with the matter. These are the two ways in which it proceeds. Now, the important thing is that about the arrest as such. Now, a person who is arrested, he has to be, there are certain things which are given in the CRPC, which the government, which the police has to follow. And D.K. Basu has given further guidelines with regard to the information of the grounds of arrest to the person who has been arrested. Then his examination, which is necessary by the medical practitioner about his health and safety. And the important thing is that as far as the person who is arrested is concerned, the information has to be given to his relatives, to the friend, etc. All those protections which are elaborately mentioned in the Supreme Court judgment D.K. Basu And as a matter of fact, the guidelines which have been given in DK Basu, in certain cases, like I found in Delhi, a form has to be filled up by the police while arresting, that all the guidelines have been complied with. Though one doesn't know whether filling up of that form, when it is not done, though the judgment says that the court can take, you can file a contempt petition before the court, and court will take cognizance if it is not followed. But I don't think in any cases, it is happening that people are going to the Supreme Court and saying that DK Basu guidelines have not been followed. A person who is arrested cannot be kept in the custody of police more than 24 hours. He has to be produced before the judicial magistrate, who is nearest in the area jurisdiction in which the person has been arrested. Now, there is a time limit which has been prescribed for completing the investigation beyond 24 hours. In any case, beyond 15 days, no police custody is permitted. The investigation time which has been, they have increased it up to 120 days, which has been challenged, that you can't keep on investigating a matter without even filing the police report. Now, one of very important things with regard to the implementation of criminal law system is that ad nauseam the investigation continues, in spite of the time limit which has been provided by the statute. So one of the issues which is pending before the Supreme Court is what are the consequences if the investigation is not completed, say within the 15 days, 60 days, or with the upper limit, which is 90 days. Whether the investigation thereafter should be only with the permission of the court, and there is a maximum limit beyond which, if it proceeds, whether the court should grant bail to these persons, because their personal liberty and life is affected because of this extension of time and the police not performing its obligation. Now, as I said earlier, the cases which are, if it is registered as the 4 kinds of trials which take place, the summary trial, as we call it, in a very summary and petty cases, then there is a summons trial, warrant trial, and sessions trial. This is how the trial takes place. And in cases which have started through the police report, the method which has been mentioned of trial is slightly different than the cases which have commenced on filing of a complaint. Then ultimately, after the trial is concluded by recording the evidence, etc., and the prosecution and the defense, then it results in the judgment, which is either conviction or acquittal. Now, cases where the court finds that the victim has to be provided compensation, there is a mechanism which has been given to compensate the victim. And recently, by virtue of a provision which is 357A, a victim compensation scheme is required to be framed, and how the compensation will be granted, which will be in addition to fine. Then there is provisions which have been added regarding free treatment of the victims, and also the compensation which is to be awarded if the arrest of a person is found to be something in violation of law, or his rights have been affected in doing the arrest, in making the arrest. Now, in looking at the situation that the police so many times indulge in the keeping the person under detention for a long time, which results in either the torture or the death of a person inside the police custody or in the police custody. In those situations, the court has dealt with in number of cases that in those cases, person has to be awarded compensation, and also action to be taken against the police officers who have illegally detained the person in police custody for a long time. There are cases, as I mentioned earlier, which have been framed concerning the arrest, how the arrest is to be made by the police officers, and those guidelines have been given in a well-known judgment, D.K. Basu. Now, police can arrest a person and the provision says that the arrest has to be made in a lawful manner. Now, so many police encounters which we find are taking place. There are two things which are provided in CRPC. One is that if a person, while in a cognizable offense, the police is making arrest, but he tries to escape in some way or uses force which is of a magnitude that which may injure or cause injury up to death of a police officer. In those situations, the police can exercise the power of using weapons, etc. The other power which has been given is right, which has not the power, but the right which has been given to the police in case the death is caused, that is to say the police encounter happens, is to prove it as a right of private defense. Now, in one PUCL judgment, the Supreme Court has laid down the guidelines which say that in cases of police encounter, what is required to be followed by the police investigating the offense. Now, the question is that in no case, as I mentioned, that police is authorized to kill another person. That is not the authority which has been given. The exceptions which I mentioned is only section 46 of the CRPC. Not in other cases, I'm so sorry. Not in other cases. So therefore, if a person is killed, what they call is as encounter, then usually the story is that they acted in right of self-defense. And that's how a person was killed. Now, in all those cases, what the court has said, that there is no provision in this criminal procedure code or anywhere giving police that right to kill a person. And therefore, in those situations, a trial has to take place. Like ordinarily, the trial takes place when a culpable homicide takes place. So therefore, in all police encounters, the guidelines have been framed by the Supreme Court saying that they are required to be followed. Earlier, there were guidelines which were framed by the National Human Rights Commission. Those guidelines have been followed. There is nothing as such, as you call, as the genuine police encounter or the fake police encounter. Police encounter essentially in law is killing a person which amounts to culpable homicide or murder, and therefore those cases have to be tried. The only exception is, as I mentioned, that they under section 46, the police shows in right of private defense that this was the situation in which they inflicted the injury on the person, or the other situations that they encountered because they opened fire and therefore they retaliated and that's why the person died. Now, as far as the bail is concerned, as I said, there are bailable offenses and non-bailable offenses and anticipatory bail. So bailable offenses where bail is granted as a matter of right, non-bailable offenses where a person has to approach the court for grant of bail, initially before the judicial magistrate and thereafter before the Sessions Court, High Court and up to Supreme Court. The anticipatory bail is an important provision because it is something which is connected with Article 21 and the dignity of a person, and therefore in anticipation of an arrest, a person can approach the court for grant of bail, which is under section 438 of the CRPC. Justice Krishna, as I mentioned, in the civil disputes, where he brought in Jolly George Varghese, the principles of Article 21 and Article 11 of the Civil and Political Rights. In one of the cases, in Municipal Council Ratlam versus Virdichan, he talked about the provision which is existing in the Criminal Procedure Code against the public nuisance, etc., which is Section 133 of the CRPC. Now, under this provision, what was said by him, that instead of starting the public interest litigation on behalf of others, this is one provision by which the concerned citizens of any city can approach the judicial magistrate, and judicial magistrate can give directions, and if the directions are not complied with, then there is a provision for grant of punishment. He referred to again Article 21 of the Constitution and questioned that why public interest is required in a given situation. So therefore, suppose there is a public nuisance in the sense that there is the municipal corporation is not discharging its obligations. There is a filth which has been created. Somebody has started a kind of a venture which is going to affect the public at large, the safety of people. If water which is stored in a particular place, which is a drinking water, river is polluted, or a tank is polluted, or some trees are cut or destroyed, these are all cases in which one can approach and file a complaint before the judicial magistrate, and the judicial magistrate has been authorized to take action. So many times when you talk about the public interest litigation, the question comes in why it should not be a local action to be taken either before the civil court or before the criminal court. And true it is that, and I have also emphasized in a number of cases, not necessary for people to rush to the High Court or to the Supreme Court. In number of cases, you can file a suit for declaration, you can file a suit for injunction, you can file a criminal complaint against the public nuisance which is taking place, and you can get the relief quickly sometimes in a local area than coming to the Supreme Court, because in these provisions, the question of locus standi is not there. Any public spirited person can file a suit under Section 91 or a complaint under Section 133 of the Criminal Procedure Code. This ends actually as far as the description of the district judiciary is concerned, both the civil and criminal side. Now, I may mention here that whatever is decided by the district judge or by the sessions judge, usually a district judge is also given power as a sessions judge, and that's why we say district and sessions judge. So decision taken on the civil side, decision taken on the criminal side is appealable before the High Court, and from High Court ultimately the special petition can be filed before the Supreme Court, which is a special jurisdiction which has been given under Article 136 of the Constitution. So this is the hierarchy in which the civil and criminal cases proceed. Now, as far as the Constitution is concerned, or whether it will be better that I take some questions now and proceed, or this is all right?
Sir, you can take questions, sir, now. If you can.
Yes. Are there any questions with regard to the district setup, civil and criminal side? So if I can answer those questions.
Yeah, one question has come specifically with regard to that.
Yeah.
Who has the final authority to appoint judges in local courts? So the appointment of judges with regard to
The
that.
appointment of judges ultimately, there is a procedure which has to be followed, but the appointment procedure ultimately is within the control of the high courts.
And now there have been many questions with regard to the entire public interest litigations in the Indian court system. So I think it will be covered now.
That will come later on. But what I emphasize, if that is clear, that both in the civil and criminal side, there are things which are the provisions which are available, where your locus standi as a person who is injured is not necessary, and you can initiate an action either the civil side or the criminal side, and which Justice Krishna emphasized in two judgments which I mentioned. Now, that is something which is not developed, and that ought to have been developed for the reason that if we want people in a local area to be conscious of their rights so that they can take action. Now, on that, if there are certain questions or anything with regard to any of the provisions, on bail question or on the arrest provision, because I am just giving the skeletal structure, I am not going to the merits of those things, what should be done, not done. That's not probably my mandate, so therefore I am not doing that. When there is no question, then I'll proceed further.
Only one, sir, if you can touch upon, is with regard to provision for the protection of witnesses.
A provision for witnesses.
Yeah.
There is a protection, there is a mechanism which the protection mechanism of witnesses which ought to be existing in our country, but then that mechanism is not existing in the sense that it should be protecting the, giving a proper protection to the witnesses, and it's a very important area, because if the witness protection is not guaranteed, then ultimately the entire the criminal jurisprudence itself or the criminal justice system is affected because of that reason. So that is a very, very important area which is required to be looked into and to be remedied in proper way.
I think we can go forward, sir.
Now we have, as far as the Supreme Court is concerned, the Constitution is concerned, we have two provisions which are very important. As the Supreme Court, we have Article 32 of the Constitution. Now, Article 32 of the Constitution is a right by itself that a person who suffers, his fundamental rights are affected, then as a matter of right, he can approach the Supreme Court. So besides the fundamental rights being there, the accessing Supreme Court under 32 itself is a part of fundamental right. And it has been said repeatedly that it's duty of the court in a democracy governed by the rule of law to see that the fundamental rights violation of a person, they are remedied and appropriate relief is granted to the person. Now, it's one thing that a person who is affected can approach the Supreme Court because his fundamental rights are violated. But any person in the public can approach the Supreme Court by filing a writ petition under Article 32 of the Constitution, saying that a particular law is unconstitutional in the sense that it is violative of the fundamental rights. So that is something which is given to a person whether he is affected or he is not affected. Anybody from the general public can file a petition challenging a provision of the statute as being unconstitutional and violative of fundamental rights. But of late, and this is where the question comes in, that the public interest litigation started. Now, in the public interest litigation, normally in these cases, we find that there has to be a list in the sense that you are injured, you are affected, except that in cases which I mentioned where you are challenging the validity of a particular statute. But can you approach the Supreme Court? And I'll come to the High Court also under Article 226 of the Constitution, when the injury is not caused to you directly. So it is a case where the list arises not between the private person or private person and the government, but it is that the poor people en masse, the environment as such, that is to say the rivers are polluted or the trees are cut, the persons who are bonded labor, they are suffering. So all these persons who are illiterate, they are not able to espouse their cause. Those are the cases in which how to ultimately ensure that the guarantee which has been given in the Constitution with regard to the protection of fundamental rights is fulfilled. And it is at that juncture, what was said, and the entire debate started from Maneka Gandhi, and in Cooper's case, where they said that you cannot put them in segments, different segments. And it's a fabric, virtually, the human rights fabric on which the fundamental rights are the patterns which guarantee the that the person's fundamental rights will not be taken away. But the question of locus standi finally was settled in S.P. Gupta in 1982. And that is where the question of locus standi was interpreted in a different way. And the interpretation was that any person, public spirited person, can espouse the cause of poor, illiterate, downtrodden, bonded laborers, those who cannot access justice. Then this was one part. The second part was that looking at the developments which are taking place, because the government proceeds with the development projects according to its own policy, and that policy may be fundamentally wrong. It may be violating the rights of people, the fundamental rights of the people, affecting them in a very serious way, in a grave way. Now, in those cases, the executive action of the government can be challenged before the court. There are cases under this category. You find the case of corruption, which are affecting ultimately rights of the people, the illegal mining cases which are there, loss of exchequer because of the wrong policies of the government. As I said, the case affecting the environment can also come within this category. And then there are certain cases, because not everywhere that you find that the laws cover the fundamental rights which are guaranteed by the Constitution. So in those cases, when you take up those issues before the Supreme Court has looked into those cases, and under Article 32 of the Constitution, using its power under Article 141 and 142 of the Constitution, have framed the guidelines. Now, you know that in the sexual harassment case, in Vishaka's case, because there was no law existing at that time, the Supreme Court framed down the guidelines. Similarly, with regard to foreign adoption, the guidelines were framed by the Supreme Court. The functioning of CVC guidelines were framed. So there are a number of judgments which have come where the Supreme Court finds that there is a gap, and because of the gap, there will be violation of fundamental rights of the people guaranteed under Article 14, 15, 16, 19, 21 of the Constitution, that the guidelines have been framed, which will be acting like law till a proper legislation comes in. So that's another thing which has been done in the public interest litigation domain. As I mentioned already, like in the sexual harassment cases, the Vishaka and the police encounter cases, where PUCL approached the Supreme Court and the guidelines have been given, because there are no guidelines as such existing in the CRPC, IPC or any other law. There is no special protection which has been granted to the police. So what is the duty and obligation of the police? What is required to be done when the encounter takes place has been given in the PUCL case. So the public interest litigation field has now become a very big kind of a big dimension, and in that dimension now probably most of the things which are being done by the government, and because of the executive excesses and executive lapses that people are approaching, the laws which are being passed by the legislature in so many cases we find are not appropriate, and therefore in those cases also the challenge is being made before the Supreme Court under Article 32 of the Constitution. There are people who are affected in different states, so therefore the challenge comes before the Supreme Court. Now I'm not going into the functioning of the Supreme Court, that how these challenges are ultimately addressed by the Supreme Court. That's a different field. Whether the Supreme Court is really discharging the obligations which have been given to it under the Constitution is a different thing. Though recently you saw that how the problem of migrant laborers was dealt with by the Supreme Court, which Henry was mentioning, and according to me, it is totally giving up whatever duties which have been duties and obligations which have been put on the Supreme Court for seeing that people's constitutional rights are protected, preserved and protected. Now, there are judgments which have been given, and all these judgments you'll find are judgments within the public interest litigation domain, expanding the scope of Article 21 of the Constitution. Now, like you'll find that 21, they say right to go abroad has been included in Article 21 of the Constitution. Right to privacy under 21 of the Constitution. Right against solitary confinement is under 21 of the Constitution. The right against bar fetters is under 21 of the Constitution. Right to legal aid is again part of Article 21 of the Constitution. This is the liberal interpretation which has been given. The expansion of Article 21 by the Supreme Court. Right to speedy trial. Right against handcuffing. The right against delayed execution. The right against custodial violence. The right against public hanging. Doctor's assistance. Right to shelter. Now, these are some of the cases which have been covered within the parameters of Article 21 of the Constitution. And 21, besides the municipal sphere, as we call it, has also touched upon the international law, like the human rights, the NHRC, where the human right has been defined not only as part of Article 21 of the Constitution, but what is contained in the civil, political rights and economic, social, and cultural rights. They have all become part of Article 21 of the Constitution. In number of other cases with regard to environment, they have taken the international conventions as elucidating and effectuating the right under Article 21 of the Constitution. So the international conventions and the commitments have also entered in the domain within the Article 21 of the Constitution. So in that sense, as far as the rule of law is concerned, it's not merely what is provided by the Constitution, but what we commit internationally is also included. And that has happened because of so many public interest issues which have been taken up before the Supreme Court. Now, if you look at similarly like Article 21, if you look at Article 19, now Article 19 talks about the freedom of speech and expression, but it has been expanded from the very beginning, say 1950-52 onwards, that it includes freedom of propagation of ideas. Free censorship is against the restriction on the liberty of press. Then the right to publish and circulate one's ideas, opinions, and views, part of Article 19(1)(a) of the Constitution. Then citizens' right to speak, publish, and express their views, as well as the right to people to read, is part of Article 19(1)(a) of the Constitution. Then citizens to exhibit films on Doordarshan is a part of 19(1)(a). Then information regarding functioning of the government must be the rule, that is to say how the government is functioning and people's right to know is also part of Article 19(1)(a) of the Constitution. Then right to know every public act, everything that is done in public way by their public functionaries is part of 19(1)(a). The affairs of the government is to know, and that's where the PUCL judgment comes in, where we said it is necessary for the voters to know the antecedents of the person who is candidate who is contesting the election. That is to say, knowing about whether he has any criminal record and also about his assets which he possesses. So this is what we said is that before a voter goes to the booth and casts his vote, he must know all these information about the candidate, and then only he can cast his vote properly. That's his right under 19(1)(a) of the Constitution, which was accepted by the Supreme Court, and the required changes were brought within the provisions of the Representation of People's Act. So this is the domain as far as the article, and then the interrelationship between the fundamental rights and directive principles is also important, because the directive principles really show how the progress has to be ultimately made. And the directive principles have been read with the fundamental rights. And Meenakshi Mill's case and other cases, the court said, the directive principles can also be read with the fundamental rights, can be implemented by the Supreme Court and by the high courts. The Though in number of cases, it is also said that as far as the directive principles are concerned, they cannot be directly implemented by the courts, because it is in the domain of ultimately what is to be done in future. And but it is necessary that as far as the legislative process is concerned, that the directive principles are followed. So if you have to make a law, you must look at guidance from the directive principles, and the law which is made in violation of the directive principles. And as directive principles are read along with Article 14, 21, 19 of the Constitution, such a law can be said to be not only offending the fundamental rights, but also against the directive principles of the Constitution. Um, uh, Now, the High Court is concerned. High Court, in that sense, has the larger jurisdiction, because it's not only the fundamental rights, breach of fundamental rights, that a petition can be entertained. It can entertain petition when the violation of other rights is taking place, which are in the public duty concept, as we call it. Now, the High Court, while entertaining the petition under Article 21 of the Constitution, can issue different writs and also direction and declaration. Like Supreme Court can also issue a writ, direction and declarations. The High Court can also do it. In a number of cases, the High Courts, like public interest litigation, also you can initiate under Article 226 of the Constitution. Before the High Court, you can also ask for enforcement of the public duties. So suppose there is a private school, but discharging the public obligation, it is open for the people to file a petition on Article 226 of the Constitution vis-a-vis that the public duty concept. And there are a number of cases which have been taken up by the Supreme Court and High Court, where a public injury has been caused. For example, that suppose you are illegally detained, or the arrest has taken place which is not in accordance with law, or for any other violation which has taken place affecting your fundamental rights under 14, 21, etc., by the police or any authority. Under the public law concept, you can approach the High Court under Article 226 of the Constitution, saying that because of that infringement of my rights, fundamental rights, injury has been caused to me, I have suffered. And number of cases, the High Court has directed and Supreme Court has directed that a person has to be compensated under the public law domain concept. So the compensation can also be granted by the High Court. The High Court acts within its territories, but where a cause of action arises, for example, in some other state, then depending on the cause of action, a writ can be issued by the High Court even outside its territory, in order to see that a relief is granted to the person who has approached the High Court. Now, as far as the legal aid is concerned, legal aid was prevailing even before the concept of PIL came. But then now there is a merger, because as far as the legal aid is concerned, the idea was that anybody, even in the private sphere where he has suffered a private injury, he can approach the legal aid committee. And I remember that the legal aid committee just started long back by a report which was given by Justice Bhagwati and Justice Krishnaya. And there was first legal aid body in the country was Indian Council for Legal Aid and Advice, of which, according to the Constitution, all the Chief Justices and judges of the Supreme Court and even the High Court are a member of that particular legal aid committee. Earlier, even the fine, etc., award or costs awarded by the court used to go to this particular legal aid committee. But now the government has come out of late with their own legal aid committees, and it has become a very effective system in one sense. But legal aid is also with the liberal interpretation of the locus standi concept. It is also a part of even the legal aid bodies. Legal aid in the sense that those who are working even in small areas, any town, any district, any state, can take up the causes not only of the individual person who has suffered individual grievances, but also cases where the public has suffered in totality. In the sense, a group of persons are affected because of the infringement of their rights. A legal aid committee, a legal aid board, a legal aid body can take up the cause. I am associated with the Indian Council of Legal Aid and Advice for more than 30 years. And at present, I am chairing that legal aid body. But I find that earlier people used to come a lot, but somehow the people still come for advice. But as far as the advocates are concerned, not many advocates are taking interest in the legal aid activities as such, which I think is important. Yeah.
So just a word that we are having an afternoon session on legal aid. Geeta is doing it. Geeta Ram session.
I'm not going to that part. I'm just mentioning the legal aid earlier used to be providing relief to the people who are injured privately, in the sense because it was a private injury and list between two individuals, or the individual or the government. Then the legal aid used to be provided depending upon his financial viability, etc. The poor person, then the legal aid will be given. I'm saying that the role of legal aid has also changed with the liberal interpretation of locus standi concept, and the legal aid bodies now take up not only the causes where a private injury is caused, but where the public injury happens, and those causes are taken up by the legal aid bodies. So the role of legal aid, in one sense, is very, very important as far as, and as I said, it has been read as part of Article 21 of the Constitution in giving redress to the persons whose rights are violated, whether the legal and constitutional rights are violated. And that's why the court said that it is necessary, it should be a part of Article 21 of the Constitution. But that's a larger area and dimension, which Henry says that somebody else is taking up this session. So I'm not going to those issues. But broadly,
questions, sir, if you don't mind.
Pardon?
Can we go into a few questions? I'm sure there are questions.
Yes. No, that's what I'm saying. I was going to end it. So this is the broad framework as far as the structure is concerned of the civil, criminal, and the constitutional part of it. As I said in the beginning, that I have not gone into the niceties of it, just a framework, how you can approach, because that's also important to know. Approach the court in what way it can be done for redressal of individual injuries or the public injuries. Yeah, now the questions can.
Matthew, please.
Yeah, thank you, sir. Thank you for a very informative session. There are two questions. I'll put the first to you. Now, a participant wants to ask, in instance of an incident affecting the rights of many, for example, cutting down of trees, etc., what recourse under the law one should take? Should they go for a action under remedy under an appropriate law, or should they go for a public interest litigation?
See, the question is that as far as the environment is concerned, it is part of Article 21 of the Constitution. And if the tree felling has taken place without getting any permission under the Forest Conservation Act, then one can approach even directly the High Court for raising this grievance that it has been done illegally. It is also open to a person to go before NGT, because in so many cases they say, as far as the environment is concerned, you should approach us. So it depends upon the bundle of facts which are there, and whether in a given situation a person should be advised to go before the High Court or before the NGT. It's open actually to agitate, but in certain cases the High Court may say that no, you approach the NGT for this particular purpose. So it depends on the facts of the case, but then both these four are available.
Thank you, sir. The next question is, do the courts impose fees with regard to filing public interest litigation? Article 32, do the courts impose fees? Like, are the fees to be paid? Are the costs associated with it?
Okay. No, there is actually some amount of court fee which is required to be paid when you file a 226 petition, because as far as public interest litigation is concerned, there is no such category which has been given separately. It falls either under Article 32 of the Constitution or Article 226 of the Constitution. So there is a fixed amount which has to be paid by a person for approaching the High Court or the Supreme Court.
There is one question, but I don't think we have time to go into that. But I'm still sharing because those who would like to listen to you with regard to your experiences and what you can share with regard to Narmada and the response of the Supreme Court.
Yes. As far as Narmada, see, I started with the Tehri. Tehri was probably the first case, and then the Narmada started. And in all these cases, let me tell you one thing. What I found was that the decision which was taken by the government was flawed, in the sense that they neither took care of the environment as such or the problems of the local people. We take, I'm just, I'll be brief, but then indicate the points. There is concerned, it's in a seismic prone area, and there was no environment clearance which was given. Then a body was set up, and it was given a conditional clearance, and on the basis of conditional clearance, the Tehri Dam was built, which affected lots of people. And the rehabilitation case, which I'm saying is more than 30 years, that the rehabilitation case which started in the Supreme Court, then the Supreme Court said you go before the High Court, giving directions, those directions were flouted, the dam was filled up, we came back again to the Supreme Court. Supreme Court then looked into the grievances because of filling of dam, it was causing damage to the people who are living in the other parts of the hill. So another set of people wanted that they should be rehabilitated. So we raised that point. There was a considerable progress, but again, Supreme Court, probably tired of pendency of the case, said you go back to the High Court. Now it is again pending in the High Court. Now look at Narmada situation. Again, look at the kind of more than 200 kilometers of the reservoir or the filling of the water in that kind of situation, affecting the villages and places which had, very high kind of a yield in the agricultural land. The entire thing was submerged, and without even planning or pre-planning the rehabilitation process, rehabilitation of the poor people. See, every project of this nature, in case number one, that you have to decide the cost ultimately of these projects and the impact ultimately on the people which it will be causing. Now that assessment is never done. And to the environment. In the case of Tehri, as well as in the case of Narmada, Sardar Sarovar and other cases, there was no proper assessment which was done that how much damage it is going to cause to the environment and to the people. And the provision that there should be a prior provision for rehabilitation of the people, that these are the number of people who are affected. The number went on increasing, and even after 20 years or more than 20 years, people are still awaiting the rehabilitation process, both in Narmada, Sardar Sarovar, Omkareshwar and other cases. Some money has been paid because the promise was that they will be given land for land. Nobody got land for land, only few got it. Others are paid compensation, so therefore you with that money you can buy land elsewhere, because these people know only the agricultural operations. So therefore, difficulties these people faced. This kind of a development process and the way in which the courts behaved was not proper, because the people's voice should have been heard and they should have been granted the rehabilitation benefits, violating their right under Article 29 of the Constitution the moment you approached, because these were clear cases of violation of the promises which are made by the government authorities before starting the project.
Thank you, sir. Thank you. Henry, you would like to comment? Henry, you're muted.
I would like to thank you, sir, for this overview. It's a difficult overview, but I think nevertheless it is a hopeful overview.
It was not very effective. I do not know, because there was no focus thing. So therefore, I only gave a structure of the position in different court systems. Maybe sometimes, when things are put more focused way, that this is what you have to say with regard to a particular district court's functioning, etc., that you can deal with it more effectively. But then overview I have given just to.
With your permission, can I ask the participants whether they have any further questions?
Please. True.
And if they have questions, whether they can email it on their online IHRE email ID, we pass it on to you. And then you could do a WhatsApp voice message. Your son would be able to do the voice message, so that there's no writing needed. And that could serve to go back to them. I heard a few whispers about your comments, wanting to know your comments on what is happening in the Supreme Court today with PILs and the way PILs are.
As I said, that's not the, one can go into that question, but then.
I will send you those questions separately.
Okay.
So that people are able to get a good balanced view from a senior person like you, who has been in the Supreme Court from 1982 onwards. It's a long tenure. And I know, like many others, the respectful judges have for you. And let me put it that way and leave it at that. Thank you very much, sir. We close.
Thank you very much. Sorry for the inconvenience in the beginning.
No, sir, no problem. We managed it, sir. Okay. At least I'm a bit relieved, because some introduction for tomorrow has already been done today. Okay. Thank you very much, sir. Participants, thank you very much. Sorry for
all the participants, sir.
Thanks once again for understanding the inconvenience this morning. But we will be at 3:45 this afternoon with Geeta Ramseshan on the legal aid movement in this country, and then the Legal Services Authority as it acts today. The legal aid movement is different from the Legal Services Authority today. So you need to know the movement and then the authority separately. Then you'll respect the concept. There's a lot of pro bono legal aid work that people like Mr. Sanjay Parikh continue to do even today, which is not known to the world. I think that is important. That is part of being the larger movement for pro bono legal aid work in the country. Thank you. Can the facilitators alone remain back while others leave? I need only 5 minutes. I know there are group meetings which are being held. At least Saji's group is meeting. So, matter of 3 minutes. So others can leave. If you leave fast, I'll have the facilitators in for just a consultation for 3 minutes. Max 3 minutes. Promise 3 minutes.